Okay. Good morning to one and all. Today, what we are going to discuss is nothing but the liquidation of companies in corporate accounting. First, you should know what do you mean by the term liquidation. Simply, liquidation of company refers to a process in which a company's existence comes to an end. In simply, we can call it as the life of the company comes to an end. For this, we have to follow certain legal procedures and process for this liquidation process, because we all know company is an artificial person created by law and it is ended by law. Then next comes the reasons for winding up of a company. First one is accomplished the company's objectives. If the objective of the company for which it was established have been accomplished, then they move for winding up. Then next reason is unable to carry out its main object. Suppose if the company is unable to carry out its main object, for example, if the company is sick, it is not making profit, then they decide to make a winding up. Then next comes dispose of its business. If company has to dispose of its business or undertaking to another company, then also the company decided to wind up. Then next comes the unable to pay its creditors. That is, if the company is unable to pay the amount to its creditors, then they go for winding up. Then next comes the modes or ways of winding up. There are three ways or that. First way for winding up is compulsory winding up. Then next comes voluntary winding up. Then finally it is relating to the winding up subject to the supervision of court. So now we are going to discuss what are all the grounds for compulsory winding up. In that first ground is, if the statutory report is not filed with the registrar, then the company must go for compulsory winding up. The next situation, that is, suppose if the company fails to hold the statutory meeting that is prescribed within the time given by the Companies Act, then also they go for the compulsory winding up. The next ground is, if the company does not commence its business within a year from its incorporation. Suppose if they get the certificate of incorporation, means then within 1 year the company must start, otherwise they go for compulsory winding up. Then next comes, if the number of members of the company falls, that is in case of we are all know, in case of private the minimum number of members in private company is 2, and for public company it is 7, no. So if the number of members of the company falls below the minimum level, then also they go for compulsory winding up. Then final ground is nothing but, if the company is unable to pay the debts in full, then also they go for the compulsory winding up. Then second way of winding up is nothing but voluntary winding up. In this there are two grounds for voluntary winding up. The first ground is nothing but when the fixed period for the duration of the company had expired by the articles of association, then they move for voluntary winding up. The next ground for voluntary winding up is nothing but, if the company passes a special resolution to wind up for the company's voluntary winding up. Then next comes the third way for winding up, that we call it as winding up under the supervision of the court. In this also there are two grounds for winding up under the supervision of the court. The first ground is nothing but, when a resolution has passed for voluntary winding up by company, then the court may order that it shall continue to the supervision of the court. Then next one, if the company passes a special resolution to wind up the company voluntarily. Then next comes, who is a liquidator? Now we are going to see who is a liquidator and what are all the things the liquidator must do at the time of liquidation process. So liquidator is nothing but the person specially appointed for conducting the liquidation proceedings of the company is called a liquidator. He is only responsible to manage the entire liquidation process. That is his duty. We know what are all the process that is to be made at the time of liquidation. All the process, that is the entire process, must be managed by this liquidators. For this, he get a remuneration that we call it as the liquidator's remuneration. Then next come the statement of affairs. What do you mean by the statement of affairs? So a statement of affairs is nothing but it is a document that contains a detailed company's assets and liabilities at the time of winding up. Then next, it is generally prepared by the liquidator or the person specially appointed by the court or by the company at the time of liquidation. Then next it is relating to, we have to prepare the statement in a prescribed manner. In a Companies Act, we know there are various formats are there. According to that format only, we are going to prepare the statement of affairs. So in a prescribed manner, we have to prepare the statement of affairs. Then next comes, it has to be open for inspection by any person. That is, after preparing the statement of affairs, we must put this statement of affairs for open for the inspection. Then next comes, in the statement of affairs, we are going to make a list from list A to list H. The following are the details of the particulars that is to be given in the statement of affairs can be summarized as follows. These are all the various lists, that is list comes from list A to list H. So now we are going to see what do you mean by the term list A and what it includes. Okay, so list A gives a complete list of assets of property which are not specifically pledged in favor of secured creditors. Then next comes list B. So list B gives the list of assets which are specifically pledged with creditors, both fully as well as partly paid up. That is, from list, there are various lists or there, list A to list H, but if you take list A and B, it is particularly related to assets of the company, whereas in case of list C to list G, it is fully related to the liabilities of the company. Okay, so list A particularly relate to the assets which are not specifically pledged, but in case of list B, it is specifically pledged. Then next list constitute the list of preferential creditors and their amount dues. Then next comes list D. List D, it is a list of debenture holders and their name, and they are having how much they are having, their floating charges, that and all these lists constitute. Then next list is nothing but list E. The list E is a list of unsecured creditors and the amount dues. Then next comes list F. List F contains the name of preference shareholders and the holding of number of preference shares. Then next comes list G. It is a list of equity shareholders together with the amount of the shares held. Then final thing in the list is nothing but list H. So list H is a statement showing the surplus or deficiency in the statement. That is, if you are preparing the statement of affairs with the help of list A to list G, we are getting the answer. No, suppose if you are getting the answer in positive means, then that is to be take it as surplus. Suppose you are getting it in a negative manner means, that is to be take it as deficiency. So list H represent, it is a thing that is that list shows the surplus or deficiency in the statement of affairs arose as a result of the profits and losses of the company. So that's all related to today's session. Thank you.